University and the Delhi University and any other institution declared by Parliament by law to be an institution of national importance. I submit the word university is a mistake and it ought to be institution. And I hope you shall permit me to substitute it because they wanted it to make it a broad-based one, not just university, but an institution. There is no fundamental change in this, except that the latter part permits also Parliament to take over any institution which it thinks is of national importance. We have the IIMs, we have the IITs. In fact, IIMs, IITs, my lords would have seen, they come under 64. Now, the matter doesn't really stop there, my lords. The reason why I'm highlighting...
Is there any discussion on the importance of the use of the word national in NT66? I didn't find it here.
There is one history to this.
So we'll find something in the...
drafting committee.
Yeah. Why was the word national used in NT66?
I'll tell one thing, my lords. There's a history to this.
Some reason. I mean, we have to, because, you know, if you have something in the drafting committee, that will be very useful.
In fact, we discussed this, my lords. Between us, we discussed, my colleagues and all of us spread out. We couldn't really get anything specific on the expression national importance. But one thing is important, my lords. 1935 Act contains institution of national importance. What the history for that is something slightly different. The history there is education was part of provincial legislative powers. Then they wanted certain institutions to be subject to imperial legislative powers. So they added Banaras. Thereafter, they added AMU also. In fact, in my submissions, I have referred to that, my first submission. Just have a look at that. Volume 4C, just have a look at that. Volume 4. C. That's right. I'll show that. Page 43. Please see a glance. No, in fact, the previous one. I'm sorry, Mr.
No, this is something else.
Page
the Aligarh Muslim University. This seems to be the bill in 1920.
1920. Now, please see the third paragraph there. Honorable members are aware that education, this is the one. Education, including university education, has in the past been a provincial subject. Legislation regarding the Banaras University was framed in consonance with that state of things, and all official control in consequence reserved to the provincial government. Recognizing the all India character of the Banaras and Aligarh universities, the rules framed under the new Government of India Act have now proposed that these two universities should be a central subject, and the responsibility in connection therewith will henceforward rest on the shoulders of the Government of India. This is the basis. At the same time, the Calcutta University Commission have commended the foundation of universities of the unitary teaching and residential type and have proposed that universities generally should possess greater autonomy in the administration of their internal affairs. Page 43 in 4C. My Lord Justice Datta has. I'm reading the third paragraph. That has been the case hitherto. As a necessary consequence of this constitutional development and of change of policy, various modified provisions have been introduced in this bill, which I venture to think constitute what will be recognized by honorable members as distinct improvements. In forming their own judgment regarding this claim, I would ask the honorable members to bear three fundamental and, in my humble judgment, indisputable principles in mind. In the first place, no government, be it purely British, exclusively Indian, or a combination of both, can reasonably be expected to deprive itself absolutely all control over education. The real test of the liberal character of a measure like this lies in the nature of the agency and the extent of control proposed to be exercised. In the second place, in the new conditions upon which India is now entering, official control no longer means what it did in the year 1915. With the introduction of a popular Indian element in the provincial as well as the imperial government, official control will in the future have an entirely different meaning. In the third place, the substitution of control by a constitutional authority consisting of a number of persons for individual authority is on the face of it a step in the right direction. This is again indicative of the manner in which and the reason behind my lords putting in place all those provisions in the 20 Act. And this, we have encapsulated, my lords, the history of this in my submissions to A, my lords. Kindly, my lords may make a note of it. I won't read it just to save the time. My lord, this is the.
Could you read the next paragraph also?
Then, all right, I'll do that, my lords.
43 last paragraph.
A glance, may I read it, my lords? A glance at section 6.2, 17.5, 18.5, and statutes 8.1, 10.1, and 19.1 of the Banaras Hindu University Act will make it clear to the honorable members that the visitor, that is the Lieutenant Governor of the United Provinces, is the main agency of control in the case of Banaras University. In the present bill, in consonance with the central nature of the subject, much of that control is transferred to the Governor General and Council, an authority which under the Government of India Act will henceforward include 3 Indian members. Under the Banaras Hindu University Act, all new statutes or additions to statutes or amendments or repeals to statutes other than those providing for the instruction of Hindu students in Hindu religion require the previous approval of the Lieutenant Governor, who may sanction, disallow, or remit for further consideration, except statutes affecting the constitution of the university authorities, which require the previous sanction of the Governor General and Council. In this bill, that power is proposed to be vested in the Governor General and Council. Moreover, the Governor General and Council will, when exercising the power so vested in him, have before him the opinion of the visiting board, which will include the ministers, one of whom will himself be in charge of education, so that the Government of India will be in possession of the views of this popular authority when exercising their own powers in this connection. Similar arrangements are also proposed with reference to ordinances. And though it has been considered advisable to reproduce in the present bill the provisions contained in the Banaras Act, giving certain powers of supervision to the provincial authority in order to secure that the proceedings of the university shall be in conformity with law, the agency even for the exercise of this power is changed from the Lieutenant Governor to the visiting body. Election of successors to the first Vice Chancellor is subject to approval by the Lieutenant Governor under the Banaras Act, while in the present bill such election is made subject to the approval of the Governor General and Council. In the Banaras Act, the Senate consists of 50 members, of whom 5 members are nominated by the Lieutenant Governor. In the case of Aligarh University, the corresponding body to be called the Academic Council will consist of 30 members, of whom 2 only shall be nominated not by the Lieutenant Governor, but by the visiting board, constituted in the manner I've just described. Honorable members will thus see that this brief comparison between the 2 agencies of control in the case of the 2 universities constitutes sufficient indication of the liberal character of the present bill.
That, when they set up AMU, they had a precedent, namely of BHU.
Correct.
BHU had been set up earlier. It's indicated that, an undertaking was given to the Hindu leaders at that time, that when AMU was set up, it will be set up on the same pattern as
Pattern and lines as yes.
And therefore, AMU itself was set up on the same pattern as BHU. That I think we also find at internal page 42, middle of page 42.
Yes.
Meanwhile, the Hindu leaders, who had in their turn approached the government of India with a scheme for establishment of a Hindu university at Banaras, guided by that practical spirit, which is one of their characteristics, accepted the conditions laid by the Secretary of State, etc. An undertaking was at that time given by the government to the Hindu leaders that the university to be granted to the Muslim community
would also
be on the lines of the Hindu university.
Therefore, my lords, 2 things really come out. 2 things really come out. One, consciously it was decided that even at the inception, it was to be taken to be an institution of national character, pre-constitution, on the lines of BHU.
But equally, this was an institution which was granted to the Muslim community.
That's
right.
Also
ignore that.
No, but one thing, my lords, as what Mr. Dwivedi was pointing out, maybe for the benefit of the community, my lords, in terms of students, etc. But please see section 8. It said that it is open to all. That's very important, my lords. Teaching of theology was for those who wanted to study it. And post-constitution also, in terms of 28.3, any teaching was subject to consent. That's very important, my lords. In fact, on that point, I wanted to just, for a minute, my lords, get out of this and get into the meaning of the expression for institutions of their choice found in Article 30. in at least 3 decisions, my lords have said what the meaning of this expression of their choice is. It's not just choice of the manner in which you will do the administration as what is sought to be projected. No. Which means an institution for the development and benefit of that minority, be it linguistic or religious, for which the institution is formed by the founders. That's how you understand the expression of their choice. Give me those 2 documents. Mention that in my supplementary submissions, what the meaning of the expression is of their choice. Just note that, my lords. Volume 2, P, my lords, P for Peter. That's my supplemental submission. 2P. 2P, page 14. I have extracted from, my lords, St. Xavier's. Given that specific extract from Xavier's, my lords. The second point, my lords, arising, coming back to the point which I was submitting.
No, but if you read the second part of 96, the case of educational institution is established by a minority to conserve their distinct language, script, and culture. This was an institute which was meant to conserve the distinct language, script, and culture of the Muslims. To that extent, it's quite clear in the enactment itself.
Not exclusively for that.
No, it allowed others to come and,
Correct.
but the object and purpose was to conserve the distinct language, script, and culture of the Muslims. That's clear from the constitution.
No, there I have a caveat, my lords, to a writer to add.
From the number of places where they've used the word Muslim.
No, they do. They do. My submission in response to what is falling from my lords is this. The primary object was not that. The primary object of the institution, even according to the appellant, was to give liberal education.
To whom?
Yes, what they said to their community, but then it was an institution which was designed and made, established by, my lords, the imperial legislature to be one open to all, with liberal education. Section 8 is a clear answer to that, my lord. Section 8. That's what in my respectful submission ought to be the consideration, my lord, while looking at this. Therefore, the second point which comes out of this is this, my lords. 1, institution of national character pre-constitution, even prior to the constitution, at the commencement of the constitution, while putting it bodily into the constitution, the understanding was this is an institution of national importance going beyond the communal tag. That's the second important takeaway from this point I want to say, my lords. And one more aspect. Ultimately, the proof of the pudding lies in its eating. Now, what does all this mean? What does all this translate into? By Parliament declaring by law that an institution is of national importance, what happens? Straight away, my lords, 4 or 5 features.
So what safeguarded was, it prevented the state legislatures for interfering.
Pre-constitution, correct.
It was a clear indication that the state legislatures will not interfere in these 3 issues.
It will be the imperial legislation.
It will be only the imperial legislation.
Correct.
And after the enactment of the constitution, only the central parliament.
Parliament, yes. That's right.
And the executive interfere.
That's correct.
So
That's right.
they wanted to save them or give them an umbrella, ensuring that it's only the central government and which interferes or will regulate their affairs.
For the reason, that's important, my lord. Absolutely right. For the reason that they are institutions of a national character and of national importance. That's the point, my lords. That's the reason why it is
the way they distinguish them. Yes, certainly that's used. But the question which was posed by the Chief Justice also was, will branding the institution or characterizing them as an institute of national importance do away with their character as minority?
It's at two levels that I want to respond to that. It's at 2 levels. Number 1, while as a proposition, it is right that it need not.
Into it.
Sorry, my lord.
We can't read it as a negative stipulation.
No, I'm saying something else. First level, yes, but at level 2,
it's a positive stipulation, not a negative stipulation.
no, the indication clearly being this: by declaring an institution to be an institution of national importance, the Parliament has decided that it shall acquire a character which goes beyond.
This is not a individual negative statement. It's
With
only a
respect, my lord.
positive statement.
No, I'm saying the meaning, therefore, constitutionally is that this now acquires a certain character where it goes beyond the position of all regular institutions, gets to the next level. And that's why I was saying how by being declared by law, so many other consequences follow. One of the main things, my lords, substantial government funding.
Guru, do we have the report of the standing committee which presented its report to the imperial legislature?
Ensured is it becomes a center of academic excellence. No, not just that. Now, in that position, it goes beyond the stage of aid to a minority institution or a non-minority institution, as the case may be. Substantial funding takes place. In fact, in my additional submission, I have pointed out from the statement of the Minister of Education on the floor of the Lok Sabha, how much money has been spent on AMU in the last 4 years. Please have a look at that for a minute. Yes. 2P, my lords. 2P, page 27, para 31.
Standing committee report by any chance?
Volume
Volume?
4A, 72 minutes. 4A, 72. 4A. Just look at page 73, my lord. This select committee's report, I presume this is what my lords are looking at. Yeah, mentioned in Bhasha, my lords. Page 73, it starts. My lords want me to refer to any specific portion, my lords, in that.
We're just trying to see if there's something to highlight, which 70, volume 4A, page 70.
73, my lord.
The select committee report is of
The date,
20.
yes, 1920, my lord.
Given you enough time?
Two more points, my lords, a
Yes.
little important, my lords.
Yes.
But my lords will take it from me that I'm referring to points which are not covered by anybody else, my lords. That we are taking care to ensure that between us, my lords, there's no repetition. Just two more things.
This formally.
Yes, I wanted to refer to 2P, page 31 of my additional submissions, where page 27. I have given the actual expenditure of the government in the last 3 years. The
Volume?
last, my lords, being
Volume?
1,005, volume 2P,
No, not on record.
page 27, para 31. The corresponding report, Lok Sabha report, is page 89 of the same volume, my lords. It's in a tabular form. 22-23 year, my lords, is 1,552 crores.
Right.
Just one more word, my lords, on the institution of
Lok
national.
Sabha report is at page 81.
The report itself is at page
81, you said, I think.
89, my lords.
89.
Wisdom generous.
Volume 2P.
89. And the relevant portion, my lords, is at
It's on the
90.
screen, huh? It's on the screen. Brothers, it's on
This
the
is not uploaded. Your 2P is not uploaded.
Oh, I'm so sorry.
morning day.
It was yesterday evening we had sent it.
No, I'm just.
I'm
it's
so
a question
sorry.
of fact.
Apology.
It's a question of fact. It's not.
I'm so sorry, my lords.
Upar jao, sir.
But
I understand the nodal council has put it up, my lords, and probably it's not
और
been.
ऊपर जाओ. ये यहाँ से नहीं control हो रहा है.
I understand it's there on the screen, my lords. No, not there.
आगे जाओ.
Yeah, this is the one. Just that's the page, my lords. Please see 90. My lords have it on the screen. My lords have that. The years
than
1920.
it's more than the University of Delhi.
That's true. That's
Almost
true.
double of that.
And AMU, my lords, we call has so many centers. Number of centers. One more thing on this point, institution of national importance, my lords, and then I'm done with this point. Please make a note of, I will not read just to save time. Please make a note of the discussion when the Vishwabharati Act was moved for declaring it by law to be an institution of national importance. There again, the national character where it goes beyond regions and particular sections is discussed. Same volume. Same volume. Please note page 43, my lords.
Which same means which volume?
The volume which I'm just referring to, 2P,
Page?
43 at 53.
Sorry.
Now the next point, my lord. Please, my lords, look at my original submissions and the additional submissions where I've elaborated on all these points, my lords. On the effect of declaration as an institution of national importance. Just to save time, I'm not going into each one of these points, my lords. Both the original submissions and further added in the written submission, additional submissions, I've pointed out all of that, my lords. I've given the crux of what I wanted to submit, my lords, on this point. The second point, the effect of the 1981 amendment. If at all, my lords, there is anything to be looked at, please look at two portions of Indira Sani 2 and Mulle Periyar, my lords. Indira Sani 2, please come to my compilation of judgments, 5D.
Page?
1240. Para 28 and 29. There, I'll just briefly give the background, my lords. Indira Sani, 9 judges, the first one, said creamy layer shall be removed from the persons who are entitled to the benefit of reservation. Creamy layer is not entitled to the benefit of reservation. Court also directed, please form backward classes commissions, identify creamy layer, remove them. State of Kerala purports to say there is no creamy layer in state of Kerala. The validity of that action, my lords, is considered in this judgment. That's the long and short of this. Please come to paragraph 28.
1240.
5D 1240. That's the relevant part. Beginning page.
A question of validation.
Yes.
One two 118 is the beginning of the judgment. I am at 1240, my lord. May I read that, my lord, para 28? The question of validation arises in the context of section 6 of the Act. It is true that whenever legislative or executive action is declared as being violative of the provisions of part 3, it will be permissible for the executive or the legislature to remove the defect which is the cause for discrimination prospectively and which defect has been pointed out by the court. The defect can be removed retrospectively too, but by legislative action, and the previous actions can also be validated. But where there is a mere validation with retrospective effect without the defect being legislatively removed.
In the sense that establishment by statute may not be then relevant.
No, that's slightly different, my lord. The point I'm
You
making.
are right. When you argue this, that in order to see who had established the institution, you'll have to go to the promoters or the persons behind, the founders. Then you cannot argue also that the establishment is by the act of the parliament.
No, there, my lords, it's one thing for the parliament to amend in the absence of a judgment. It's something totally different. The moment there is a judgment interceding, which returns factual findings and becomes final and binding on parties, thereafter, my lords, parliament cannot step in. That's where the important qualification comes, my lords. One, a factual finding, can it be subject matter of validation? Number two, once there is a factual finding which is a subject matter of adjudication by the judicial process, which is where, my lords, the importance of separation of powers becomes extremely relevant. Separation of powers, yes, the legislature has the power to undo acts which are held to be bad by removing the basis or curing the defect. But merely legislating to overcome cannot be done. Para 29, my lords, looks at that. Now, please come to Mulai Periyar. Same volume, 1033. 1033 at 1123. Please look at paragraph 157. Mulai Periyar again, my lords, very briefly. Judicial decision.
Page 10, volume 5D.
1123, it starts, my lords.
1123 at
1033 at 1123.
The other way, 1033, it starts.
At, that's right, at 1123. 5D, my lord. Same volume.
Para
157. The question, may I read that, my lord? The question whether or not the legislature, my lord, this Suryakant has, my lords.
yes.
The question whether or not the legislature has usurped the judicial power or enacted a law in breach of separation of powers principle would depend on facts of each case after considering the real effect of the law on a judgment or a judicial proceeding. One of the tests for determining whether a judgment is nullified is to see whether the law and the judgment are inconsistent or irreconcilable so that both cannot stand together. In what we have already discussed above, it's abundantly clear that on the one hand, there is a finding of fact determined by this court on hearing the parties on the basis of the evidence materials placed on record in the judgment of this court in Mulai Periyar Environment so-and-so, and on the other in the 2006 Amendment Act, the legislature has declared the dam being an endangered one and fixed the water level in the dam at
B on page 787, the next page, Placidum B.
Placidum B.
The
Yes.
impugned law is a classic case of nullification of a judgment simpliciter.
Yes.
As in the judgment of this court, the question of the safety of the dam was determined on the basis of materials placed before it and not on the interpretation of any existing law. And there was no occasion for the legislature to amend the law by altering the basis on which the judgment was.
I bowed on.
That's what you are.
This is precisely what I wanted to highlight.
But in this case, this legislature, the parliament amended the law.
No, on a factual aspect found by the court. That's where, my lords, the distinction.
They amended the law. Yes, you can argue as far as the finding of fact, who are the people behind or founders of the university? If there is a finding recorded in Basha, that could not have been changed by the parliament.
That's the whole point, my lords. On establishment, the clear conclusions in Bacha are threefold. I'm not on administration. Administration part has not been touched at all by the 81 Amendment, as what fell from the Chief Justice. Therefore, that's something entirely in favor of our argument. on establishment. Three important things, my lords. The finding is that it is by an act of legislature. One, by looking at history. Number two, it specifically says, my lords, there was an option available to put up a university with the rider that if you did that, you were not assured of recognition of degrees by the then government. Therefore, you chose the route of having a university being established. And third, the societies which formed the basis or the beginning or the genesis, they were extinguished. In fact, one point allied to that I want to say, my lords, is part of my submissions on the third point. There are at least 2-3 legislations where the expression used is where the antecedent bodies are conglomerated with the new body which is created by the statute. Page 31 of 2P, my additional submissions, I've given that example. Page 31 of volume 2P, my additional submissions. The concerned act, my lords, is the Institute of Teaching and Research in Ayurveda Act of 2020. Section 3, my lords, anteceding institutions. 2 is the declaration of the parliament that's an institution of national importance. That's at 33. Section 4, it says all those anteceding institutions, they are named. And thereafter it says are hereby conglomerated and established as a body corporate under this act. My lords got that.
Section 4.
Section, page 33. The 3 is, my lords, the definitions. 3A, my lords, will see the anteceding institutions. And please come to 4 in the next page. Please see 4.1. The anteceding institutions, namely so-and-so, 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 are hereby conglomerated and established as a body corporate under this act, and on such incorporation be called the Institute of Teaching and Research in Ayurveda.
What is the effect thereof?
The effect thereof is those institutions are not extinguished or not.
Why they still continue to exist?
No, but on the contrary, my lords, what happens is those institutions become the
Just one. What happens on amalgamation?
amalgamation. There is a fusion of both entities in terms of company law.
Similarly over here, these earlier institutions get submerged and become part of the main institute.
There, the response is this, my lord.
Yes, the legislation has, in this case, used the word dissolve, but the legislation could have realized we use the word wrongly, and let's change that word.
No, there
Just like established also.
No, in fact, in the case of AMU, the draft bill of 1911 used the expression amalgamation. That was removed. That's the next point I wanted to highlight, my lords. Please see, compare. I've given a table of the 1911 draft and 2020 Act as ultimately, 1920 Act as ultimately made. Please come to page 5 of the same volume, 2P. Please look at that, my lords. There's a tabular column we have given. My lords got that. Just see the preamble itself, my lords, what the tone and tenor was and what it ultimately became. May I read that, my lords, for a minute?
Yes.
Where an institution, a page, my lords, of 5 of my submissions. The tabular statement is there on the screen now. Whereas an institution styled the Mohammedan Anglo-Oriental College was founded at Aligarh in the year 1875 by the Muslim community under the leadership of late so-and-so, with the special object of promoting the diffusion of Western science and literature and of training the character of the students by a scheme adopted to meet the special educational requirements of the community. And whereas from the beginning, the object of the founder and the Muslim community was to raise such a college to the status of a university. And whereas during the last 35 years of its existence, the college has very largely expanded and extended and expanded. And whereas a memorial has been presented to the government by the trustees and other representatives of the Muslim community praying for erection of a Muslim university at Aligarh and inviting attention to the advantages which a university of their own would confer on their community, to the inadequate representation within their community, etc., etc. So the entirety of that is referred to. And finally, it says, whereas it has been determined to establish a university at Aligarh. Now, please see the preamble actually enacted in the right-hand side column. Whereas it is expedient to establish and incorporate a teaching and residential Muslim university at Aligarh and to dissolve the societies registered under the Societies Act, which are respectively known as Mohammedan Anglo-Oriental College, Aligarh, and the Muslim University Association, and to transfer and invest in the university all properties and rights of their societies and of the Muslim University Foundation Committee. Then please come to that part about amalgamation and conglomeration. Page 9, my lords. Section 29 in the draft.
Page 9 पे
9 में
10 पे गए.
Section 29, left-hand side column. Amalgamation of MAO College, Aligarh with the Muslim University.
Okay, amalgamation of.
My lords got that.
Yes.
On and after the date of establishment of the university, the MAO College, Aligarh shall cease to exist as a separate corporation and shall be incorporated to the university, and all property, movable and immovable of every description, etc., etc. And all rights and powers and privileges are immediately before the establishment belonging to or were vested in the college shall by virtue of this act, without any conveyance, assurance, or other instrument, be transferred to and become vested in the university for all estate and interest therein, respectively of the college, and shall be applied to the objects and purposes. As distinguished from that, so the amalgamation is what is envisaged. Please see on the right-hand side column.
Amalgamate, it says incorporated into.
Yes.
Yes.
Now, section 4 talks about dissolution as passed.
Right.
Very significant in my respectful submission.
Explanation is in the margin.
The marginal note.
They're off in a month.
Two things, my lords, I'm left with now. Points 3 and 4. They are connected to each other. Proceeding on the basis, my lords, that a pre-constitution institution is also entitled to the benefit of reservation, minority protection under 30. Now, please also bear in mind, my lords, that this really stems out of a brief discussion in Kerala education, where a submission was made saying, while dealing with the Kerala Act, which was sent up to this court for advisory opinion on its validity, one of the arguments was that an institution to claim the protection of 30 should have been established after the constitution came into existence, amongst various other arguments. In that process, this honorable court says, no, there is nothing in 30 which prevents even an institution established and administered prior to the constitution from claiming the benefit of 30. That's to be borne in mind, notes. Now, in my respectful submission, please look at it in two time frames. What was the status of the institution pre-constitution when it was established and being administered? Second is at the commencement of the constitution and thereafter. Now, I am not going into the larger question, my lords, and without in any manner seeking to dilute what has been submitted by Mr. Rakesh Dwivedi, my lords, on whether at all they can claim to be a minority institution. Large submissions and material has been placed. While adopting that in the alternative, I am submitting this. Two things will have to be established, my lords. That you were established and administered. I am proceeding on the assumption that it's a minority. And that therefore they can claim to come within the ambit of 30. That's why I'm saying it's in the alternative. Please do not take it as diluting what has been argued on the question of minority status itself. The submission is, you ought to have been established and administered prior to the constitution. You can't say at the commencement of the constitution, I will now say here, I'm putting up my hand, I'm saying I'm a minority institution. Whatever may have been my past, I'm still entitled to the protection. That can't be.
Right, thank you.
That is one, my lords. One more thing. Post the constitution, 1951, 65, all the amendments, they really, my lords, reinforce the character that is not a minority institution. In fact, one point, my lords, the approach adopted by my lords in Ram Janambhoomi, where that was, of course, in the context of private property rights. My lord said, you really look at it when old claims were being made, saying prior to 1800, prior to 1700, this claim was made, that claim was made, historical wrongs, etc. My lords had two wholesome approaches. Whatever may have been recognized under the British rule, and which is expressly accepted is all that can be claimed. One. So that's why I said 2 time frames. Look at it from the point of view of what they had before the constitution was adopted and whether it was accepted or not accepted. Alternatively, let me assume, my lords, for a minute that they had the trappings or vestiges of a minority institution in 50. I am saying, my lords, with the adoption of the constitution, the Indian Parliament had decided that it will not have even those vestiges of minority character by the 51 and 65 amendments, and thereafter, one important significant thing there, my lords, never ever was a square claim made for being a minority institution, except that skirmish, if I may put it that way, of 81 amendment. And thereafter, the 2005 proposal for giving 50% reservation. Not earlier, not after. That's a very, very important respectful point in my respectful submission, my lords. They never made a claim. Today, my lords are not looking at the validity of the 1920 Act. Will it be open to the university of all people to collaterally today argue saying, no, all this must be understood or to be held to be contrary to what is laid down by constitution benches in respect of 30? That can't be, my lords. The first ever explicit claim is 2005 when they said 50% seats for that community. Please look at it from that viewpoint. And post-constitution also, my lords have said in Ram Janambhoomi, it is for the new sovereign to decide how to treat a particular right. I've given those page numbers, my lords, in my submissions. Volume 5D, my lords. (864, 865), paragraphs 989, 990.
But how that principle apply here?
The principle applies here in this manner, my lords. Prior to the adoption of the constitution, the imperial government never treated them as an institution which belongs to a particular community. One. It was on the contrary.
That's an argument from both sides that status has to be determined first in 1920.
Correct.
And then it will have its reflection as on the date when Constitution came into
Exactly.
in Article 30.
That's right. And the second, therefore, 989, 990, my lords, and 997. My lords' decision in Ram Janambhoomi, where alternatively, my lords have also said, it is open to the new sovereign to either accept or not accept. Therefore, you look at it in any view of the matter. Look at it from the standpoint of what they had prior to 50. What the legislature, imperial legislature gave them or did not give them. Or assume for a minute they had some trappings at the commencement of the constitution. Entry 63, list 1, 51, 65, and the actual practice in the institution. 2005 is perhaps the first tangible claim of status.
That point you have made. Thank you.
Then, my lords, one last thing and then I'm done. I'm obliged, my lords, for a patient hearing. Their submission on 30, please have a look at Dr. Dhawan's submission. Just have a minute, my
So
lord.
what's the point that you're making?
The point I'm making is this. The submission appears to proceed on the basis that it is enough if it is shown that it's the minority community which is involved. The establishment and administration are the consequences of that status. Please have a look at that formulation, my lords. In my respectful submission, it amounts to begging the question. Please look at it, my lords. It's a little important because one of the key ingredients of their attack on Aziz Basha is on that. Please have a look at that, my lords. Page, give me the pages. 2A. 2A, my lords, page 73. Page 73, 2A, my lords. 1A, yeah. 1A, I'm sorry. 1A. Now, please come to the conclusions. In fact, the body of the submissions also refers to that, but I thought for ease of reference, I'll come directly to this. 73, the conclusions. Aziz Basha, my lords got that, is internally contradictory in its reasoning on facts and law. 9.2. Aziz Basha failed to recognize that the word establish and administer are not preconditions to define a minority. I read their institution, it's not found there, my lords. Otherwise, it won't be complete. Preconditions to define a minority, but the consequential rights that flow from such recognition. The ingredients of the right that flow from 30 have been stated by TMA Pai at para 50 and other decisions. With respect, my lords, the position is the other way around. If you want to claim the benefits of a minority, you must show that you have established and you are
No. There you're wrong. You're absolutely right that Article 30 says that all minorities,
Yes.
religious or linguistic,
correct.
shall be entitled to establish and administer institutions
That's
of
correct.
a choice.
That's right.
So it postulates that you are a minority and then gives you certain rights.
No, that's right.
Namely, the right to establish and administer. Therefore, the formulation that establishment and administration are concomitant rights once you are a minority is correct. It's on the basis of plain language of article.
No, I'm saying the submission appears to be that if you show that you are a minority, then establishing an administration is really something which comes thereafter. No, on the contrary, my lords, even if you are a minority and you have been involved with an institution, you have to show that you have established it and you have been administering it.
But that's exactly the point. That you cannot claim the benefit of Article 30 in respect of an institution if you have not established it and you are not administering it.
No, this is apart from, my lords,
But it doesn't, whether you have established or administered an institution does not define as to whether you are a minority.
no, not in that sense. I quite see that, my lords, I quite see that.
So therefore, this is plainly a clear construction of Article 30 as it's stands.
Very well, my lords. On that point, I have made some submissions. Please have a look at my written submissions on that, my lords.
Thank you, Mr.
One last thing, my lords, and then I'm really done.
I've been
For
mentioning
all intents and purposes.
last submission of Guru.
Please see the 2006 Central Act providing reservations for SCBCs and SCs and STs. That act provides that all central institutions shall provide reservation in terms of 15 and 16. And by definition, institutions of national importance are covered by it. So AMU will have to provide that reservation, but they have not been, because there is some provision in that act which says that if the parliament declares a particular institution to be a minority institution and certain other conditions, then yes, it need not provide the reservation provided under 15 and 16. Now, AMU has not been declared as such, but still, my lords, it's not being provided. Therefore, we are looking at what, my lords, as what Mr. Sibal said, is it merely that 50% which they claim for a particular community, or are we not looking at the larger umbrella of 15 and 16 across the spectrum? For an institution declared to be of national importance with thousands of crores being pumped in to keep it and make it an institution of excellence, and throughout has not made any specific overt claims of minority status except that 2005 or the in between 1981, my lords, amendment, which in my respectful submission is subject to the vagaries of political changes.
All right. Thank you, Guru.
I'm deeply obliged, my lords. I overshot the time, but my apologies, my lords. I'm deeply obliged for a patient here.
Navre, what is the point you want to make?
Lord, I will not repeat anything that I promised. Lord, my written submissions are in volume 2A. Page 58, Lord, it starts, but actual submissions start at page 67.
Volume?
2A, page 67.
Page 58, but
but
starts at 60. Actual submissions start at 67. Lord, the first submission that I'm making is with respect to the scope of reference, and I will, for that submissions are made, I will not, my lord, repeat that. Lord, on facts and the law of 1920, interpretation of that act to those facts, there is a decision rendered by a 5 judges bench. And that is, my lord, something which is concluded. In reference, my lord, on principle, everything can be relooked at. But those principles will be prospectively applicable, not with respect to the decision which is made, my lord, in that judgment. My lord, there is a judgment, my lord, of your lordship's court, my lord, 3 judges. I will just, my lord, read. It is, my lord, that judgment is, my lord, brought on record before your lordships in volume 5I. It's a special only, that judgment only. My lord, the citation is 2014, volume 5, page 800. And my lord, of that, the observations only in para 12. I will read, my lord, those 5-6 lines. Reference of a case to a larger bench necessarily has to be for a reconsideration of the principle of law on which the case has been decided and not the merits of the decision. The decision rendered by any bench is final inter partes, subject to the power of review and the curative power. Any other view would have the effect of conferring some kind of an appellate power in a larger bench of this court, which cannot be countenanced. So, my lord, this is what I am relying upon for the first proposition. My lord, the second submission that I want to make, my lord, is with respect to the, my lord, in my written submissions, I have used the term dangers. My lord, your lordship may read it as the pitfalls. Dangers in accepting the independent status of the AMU as a minority institution. My lord, 69, my lord, page 69, that my lord caption is there. Dangers in accepting the independent status of the AMU. Dangers in the sense, not my lord, political sense or my lord, social sense. Purely legal sense, my lord, that's my lord, my submission. My lord, the first thing, my lord, for that, my lord, for appreciating this submission, your lordships will have to, my lord, will have to bear in mind that entry 63 in list 1 will takes care of the AMU as an institution of national importance. If AMU, my lord, is conferred or recognized to be a minority institution, my lord, the parliament will be robbed of the powers, my lord, conferred under entry 63. But the wide nature of power that the parliament possesses, my lord, under entry 63 will be, my lord, curtailed if, my lord, it is recognized as a minority institution.
Other than two institutions.
I'm sorry, my lord.
Other than two institutions.
Yes, ma'am. That will be undermining the authority of the parliament. My lord, conferring or recognizing the status of a minority institution will virtually taking away the powers of the parliament under entry 63, or, my lord, diluting those powers. And while interpreting 1920 Act or any act of the parliament, my lord, the court should avoid the interpretation which will result into undermining the authority of the parliament under entry 63 or any other entry. So, my lord, this is first danger that, my lord, needs to be seen in recognizing the minority status with respect to the AMU. Second, my lord, since, my lord, parliament attempted to do that by way of 1972 amendment and 1981 amendment, my lord, that also cannot be allowed to be done by the parliament because parliament virtually will be abdicating its responsibility under entry 63. Entry 63 gives a wide power, and the moment the parliament tries to, my lord, give that status to one of those institutions, my lord, as a minority institution, parliament virtually will be accepting certain restrictions on the legislative powers under entry 63. That will amount to abdicating, my lord, the responsibility which is conferred upon the parliament under entry 63. And, my lord, that's why, my lord, your lordships put a question to the learned solicitor, can you argue this? I don't know, my lord, I need not answer that. But, my lord, Union of India cannot do something which will result into abdication of or undermining the authority of the parliament. This is second submission. My lord, if AMU is a creature by a special statute, it is, my lord, and, my lord, funded almost entirely by the government. It is a state under Article 12. My lord, if it is a state under Article 12, then, my lord, it can't do something which a minority institution will be entitled to do. My lord, my learned friend Mr. Guru Krishna Kumar, my lord, pointed out in the last submission that scheduled castes, scheduled tribes, reservation, etc., will not be applicable to minority institution. That's, my lord, what the Act provides for. Virtually, my lord, though it is a state, and, my lord, bound by, my lord, mandate of Articles 15, 16, it will not be, my lord, liable to do that only because it is recognized as, it's a conflict which will arise as a result of that. So, my lord, this is my third submission with respect to the dangers of, my lord, recognizing or conferring a status of a minority institution on AMU. My lord, there is one aspect which is covered. I will just put that the caption, and that caption that, my lord, there is a fundamental difference in created under the law and created by a special law. I have, my lord, analyzed that in my reason. I will not repeat that. Lord, one word of their choice was something that was, my lord, argued on both sides. In fact, Mr. Sibal tried to give it a new dimension, saying that even if the minority institution or minority community goes to the government and requests them to create a law for it, for creation of that institution, that also will be of their choice. But my submission on this of their choice still adds a new dimension to it. Today, what way, my lord, AMU is actually functioning? Parliament has provided for everything. Court, executive council, academic council, statutes, how to be framed, what will be governed by the statute. Statutes governs, my lord, and ordinances governs even the control of examinations, even the awarding of degrees, appointment of professors, etc. It is, my lord, the choice of the parliament. It is not any community, some different entity which is taking a decision. How do I administer it? But it is the wisdom, discretion, and the decision of the parliament which controls everything. So, my lord, of their choice, in this case, it's only the choice. Therefore, I said discretion, wisdom, and the decision of the parliament, which actually, my lord, is the manner in which the institution is run. So, my lord, this is of their choice, my lord, therefore, will not be available in case of an institution like AMU, which is a creature under the statute. My lord, this aspect also is covered. I will just paraphrasing it, and I will just, my lord, not repeat that. That, my lord, the institution is the earlier institutions, MAO, etc., are dissolved, and new institution is entities. My lord, I am putting it. The Act of 1920 achieved twin purposes. And, my lord, I am putting it, paraphrasing it, once for all. Once for all in the sense that has happened. There is something inalterable thereafter. One is dissolution of the old institutions and establishment of the new entity. That has happened once for all. And therefore, my lord, 1981 amendment cannot, my lord, seek to alter something which has already occurred, and those
Navi, I think
provisions are
down now. Thank you, Mr. Navre.
Lord, there is only one thing. Last submission. Lord, your lordships have seen entry 63. BHU and AMU are both, my lord, on par in entry 63. The moment, my lord, this is again part of that pitfalls. The moment you recognize it as a minority institution, my lord, even-handedness of the parliament's power with respect to two institutions again will be affected. What parliament can do with respect to BHU will not be able to do with AMU. So, my lord, entry 63 virtually will be rewritten as a result of that. And therefore, my lord, this, my lord, the submission made on behalf of the respondents, the other side, my lord, may not be worth accepting. I am obliged.
Thank you.
There is last submission, but, my lord, since my learned colleague reminds me, my lord, the minority status of institution under Article 30, your lordships have held that it's state specific. But if AMU is established by the parliament, treated as minority institution, what do we do with respect to its campus, my lord, on the Jammu and Kashmir? But that's the question which may arise. And therefore, my lord, that also is the conflict which may arise.
Too short.
Yes, Mr. Banerjee.
I don't want to repeat. I know I'm possibly right at the tail end, so and I'm sure.
Yes, Mr.
But there are-
Banerjee, what is it?
Just two short issues, Malaz. One, I've submitted my note, which is volume 2K, Malaz. That's what I've been informed at the last moment. Just two short points. One is in relation to the three entries. Malaz, I'm not going to, I've elaborated that in my note, but I'm just placing this. That it requires to be interpreted. There are institutions of national importance in all the three entries. So Nusaiterian sources has to be used to interpret all three. And Malaz, in relation to the first half, and Malaz, what has not been cited is, Malaz, I have quoted some of the extracts, Malaz, of Baba Sahib Ambedkar as well as Sardar Patel saying that minority protection, what is the intention of 29 and 30? And Malats, I've quoted Bal Patil, which does not seem to have been cited, Malats.
The Jain institutions claim under.
Not only that, Malats, Jain institutions, but what Bal Patil actually does is addresses the question of minority. Malats, only at the end, Malats, will recall, if my lords have gone through Bal Patil deals with the history of how minorities are formed. And it mentions in paragraph 33 specifically that the intention of the protection of 29 and 30 is a temporary way to ensure that the minorities finally disappear into the majority. So it's not to have a construction which will perpetuate minorities. Now, what we are doing in the present case is, if we say that the state can create such minority institutions and so on and so forth, it would effectively go against the intention and objective of the interpretation of, and Bal Patil, my lords will recall, it's a 3-judge bench, and my lords, I can project it, or para 33 if lordships are willing to bear with me and read the paragraph 33, my lords. It deals in great detail as to the history of, if lordship allows me to place that, my lords, I think Bal Patil would be relevant, my lords.
All right,
para 11.
We'll have a look at it.
Malaj, I only say this, para 11 and para 33.
11 and 33.
Obligements. Malaj, that's part of my note which I have enclosed.
Thank you, Mr. Banji.
Obliged.
Yes, Mr. Potteraju.
Lordships, my submission is on first principles. The original provisions of the Constitution had Article 12, 14, 15, 28, 29, 2, as well as entry 63 as one scheme. There is a new sovereign, the people of India, who gave themselves this Constitution. They chose to elevate certain institutions which were established by an enactment prior to the Constitution coming into force, and have conferred certain rights on the citizen of this country to have access to education in institutions under 29(2). The institution in question, the Aligarh Muslim University, was a 29(2) institution in which all the seats were available to the citizen of India until 2005. So for the first time, the citizen of India have been deprived only on the basis of their religion access to admission, consideration for admission on merits in the case of PG medical seats in 2005. The judgment in 1967 has upheld the constitutional status as a secular institution. Now, lordships are sitting in a combination of 7 judges deciding a question of seminal importance. The interpretation lordships will choose would have to be in sync with the constitutional spirit, which is upholding the doctrine of secularism, which we have actually enshrined as a basic feature of our Constitution. Now, what is the interpretation which is sought to be given today? The interpretation which is sought to be given today is the original scheme of the Constitution, which has conferred certain fundamental rights on an institution which is classified. My submissions in volume 2M have stated, my lords, AMU qualifies as a state under Article 12 on the day the Constitution comes into force, because it is maintained by the state. I've referred to section 35 in the 1920 Act and the substituted section which came in the 1981 amendment. Both of them mandate that the accounts and audit will have to be done and be published pre-independence, post-independence in the Gazette of India. In the pre-independence, in addition to Gazette of India, in the local gazette. Further, 35(4) post 1981 mandates the audit by the Comptroller and Auditor General. The finances which are going into the institution have been demonstrated, my lords. The scheme of the Constitution has created certain rights in favor of the citizen of this land. Now, those rights are now being diverted or being actually taken away by a parliamentary legislation which does not seek to even refer to the judgment of the Constitution bench, much less refer to entry 63 status. With great respect, my lords, entry 63 is a status conferred on an institution, not merely a origin or a establishment of a new institution. The historical background has been set out, my lords, by Mr. Ragesh Dwivedi, learned senior counsel. The background of 1916, 1920 is where we moved to a secular constitution in 1950. The new sovereign was conscious of the pitfalls of the two-nation theory and have expressly rejected it. And by rejecting it, they elevated both universities, though named as the Banaras Hindu University and the Aligarh Muslim University, as institutions of national importance. Once they elevate it, some purport has to be given to that status being conferred under the original constitution, my lords. The third point that I would like to make, my lords, is that an institution of this significance, once it is an Article 12 state, it ceases to be an Article 31 minority institution on the commencement of the constitution, because there cannot be a situation where it could have been an instrumentality of state or otherwise, but this is an institution which existed on the day when the constitution has come into force. So therefore it becomes a state on the date when the constitution comes, and it becomes Article 12. So 31 is not available to this institution, my lords. And AMU, as a creation of the statute, through its registrar, who is also a creation of the statute, cannot actually question the constitutional status of the university, which itself is a part of the original constitution. The stream cannot question the source, is my respectful submission.
Thank you, Mr.
I'm grateful.
Yes, Ms. Sachana Dave.
Wait, please, Manoj. Well, it's taking the point further. I don't want to repeat myself because already much has been said on this side. But my lords were particularly asking about the legislative debates. And I could find one paragraph which I would just read. That's in volume 4H and page 14. I can just read it, my lord.
Just a second.
Sorry. Let's where
Volume 4H.
4H, page 14.
Just
They are talking about the national character.
Just 1 second.
Yes.
At page
14,
14.
first column, down
What is
left.
That we are, this is the 81 amendment.
Yes.
Sorry, 60, yeah, because this is
No,
Chagla.
Malus,
Chagla
61,
was there.
additional compilation of legislative debates, page 14. Let's have that.
First column,
Chagla.
Aligarh University is a national institution, an institution
MC
of
Chagla, right?
Yes. The last paragraph, left column. Aligarh, my lords, have it?
Yes.
Aligarh University is a national institution, an institution of national importance established by the legislature and continued by this parliament. Parliament has got every right to deal with the administration of the university, and this sovereign legislature has no right to interfere with the administration of the Aligarh University, which is Mr. Anthony's argument. It was never accepted by the British government, although there was no constitution. And even in those days, if you look at the dispatches, I have gone through the history of this. When the Governor General sent the dispatch to the Secretary of State suggesting the starting of the Aligarh University, it was made incumbent that the doors of the university shall be open to persons of all castes and communities. Even that, British government would not permit a university to be set up to be financed by Indian money, which would be communal in its character. But as I said, they did not make this concession about this quote, which we could not keep up because of our constitution. So, my lords, taking this further, this is with regard to the national importance, the national institution. Also, my lords, if I can say, the judgment in Aziz Basha is for a standalone institution. If I can say, this is a judgment in personam. What it is deciding is the character of the university, AMU University, as a standalone university. Both BHU and AMU are on a similar footing.
I also want to read page 12, Archana,
Yes, my lords.
column 2.
Yes, my lords.
That is again Mr. Chagla's speech.
Yes.
Let's read from the right that is conferred.
The right that is conferred upon minorities, it is important to note, is to establish and administer educational institutions of their choice. My submission to this House is that Aligarh University has neither been established nor is it being administered by the Muslim community. It is not a minority institution in the sense in which Mr. Anthony suggests. I will give him the reasons. You had first the Muslim College, which was founded by Sir Syed Ahmad. Sir Syed Ahmad asked the British government of those days to establish a university, and the British government in 1920 passed the Act of 1920. The legislature of those days passed that act and established the university. Therefore, the establishment of the institution was by legislature and not by the community. Whatever might have been the origin of the Aligarh University itself was established by the legislature. Then came the constitution. Then in 1951, the amending act made certain alterations. In our own constitution, in the Union List entry 63, it is provided that central universities and other institutions of national importance can be legislated upon the parliament. Now, I cannot understand how it can be said that the administration is in the hands of the minorities. The administration of the university depends upon the law. During British times, it depended upon this act. After independence, it depends upon the act as had been amended by parliament. Does Mr. Anthony suggest that it is open to the Aligarh Muslim University or the Muslim community to change the administration of the university even to the slightest degree and go contrary to what parliament has laid down? If the minority had the right to administer the Aligarh University, then it can have any administration it liked. It can change the administration and it can close down the university. It can change the constitution of the court or the executive council. Can it do so? Even the constitution of the court, of the executive council, and of the academic council is regulated not by the minority committee, but by the parliament. There is another aspect of the matter which Mr. Anthony has completely forgotten. He has attached great importance to the fact that under the Act of 1920, the British government, as a concession, said that the court shall consist wholly of Muslims. Now, everybody know that the university is administered by the Executive Council and not by the court. The court, of course, is the supreme authority, and it is like a showpiece. It meets once a year. Lots of people come there and make speeches and pass resolutions. But the day-to-day administration, selection, appointments, and so on are carried on by the Executive Council. And it is significant that even in the British days, it was not provided that the Executive Council shall consist only of Muslims. That clearly shows that the British government did not concede the argument. Although there was no constitution, then the argument is now advanced by Mr. Anthony that the minority has a right to administer this particular institution. I say that this institution was not established by the minority, nor it is being administered or was ever administered by the minority community. That is the legal position as far as Article 30 is concerned.
What else, Miss? Anything? What else do you want
Yes.
to?
Well, so my humble submission is, Malad, Aziz Basha, who is holding the field till today, is a good law, and it is only deciding the character of one particular university, which is AMU in this case. Well, it's the parliament by the 1981 Amendment Act brazenly tried to overrule Basha's judgment, which it could not have done, my lords. I'm so deeply obliged
Thanks, Ms.
for
Dave. Thank you.
patient hearing.
I get just two things. I'm appearing for the National Commission for Scheduled Castes. Because Mr. Yogeshwar had filed the written submissions. However, Milords, there's a bereavement in his family, so I just need 2 minutes, Milords. The first submission is that the appellants have based their submissions on the extent and width of Article 31. On an interpretation of Article 31 and interpretation of TMA Pi in Inamdar, it has been held that it's only an added protective measures and it is triangular. At the top, the rights of the minority to establish institution is narrowed down and virtually zero. Hence, you cannot enter into the protection of minority institution directly as a university. Even deemed university, they first become institution of eminence. Then there is a procedure to get themselves declared. That's the first point. Second point was following this in TMA Pi and interpreting that in Inamdar, it has been held that Article 31 is now subject to Article 29(2). Once the field on any seat of any institution is occupied by 29(2), and because it is a superior right, it cannot be relegated back to an Article 31 seat. Because just 60 seconds more. Because the next point is that minority rights to establish and administer institution cannot extend to a minority university at the start. Fourth point is, Lords, the case of St. Stephen's, if we look at the factual ambit, St. Stephen's clearly said that it was established to spread the gospel, and the same charter of spreading the gospel was also registered with Delhi University. And a ritualistic religious head, that is the bishop, occupies the position as the chairman and nominates bodies. Milord.
Mr. Yatindra Singh.
Sir, volume 2C.
Give Mr. Yatindra Singh.
Your Lordships granted me 5 minutes. Probably I cannot finish in 5 minutes.
Tell us what the point is. Of course, we'll hear.
Yeah. Please inform me when the 4 minutes are over. 1 minute time, I want to tell your Lordships something which probably even they don't know about their own university. And there's a one particular case.
Why didn't we begin with that then?
My lords, I'm sorry. Lord, I have 5 submissions to make.
Yes, Mr. Yatindra.
And Lord, I will argue the traditional way. Lord, I will feel more comfortable. Just pass on. This doesn't contain any of the annexures, only my written submissions. There are 7 submissions. Submission number 1 is, number 1 is plain language should be given natural meaning and should be read as and not or. Second submission is,
Where is that, Mr. Yatindra?
your Lordships may have my this submission, and there's a
Page? What page?
written submissions, page 2.
Page 2, all right.
My lords. Second is, university was, AMU was established by, it was not established by Muslims. The third one is that it was never being administered by minority Muslims. And the fourth one is, without changing the basis of Basha case, the legislature cannot reverse it. First and 4 are settled point. Second and third are very well dealt by Solicitor General. I have mentioned them in Annexure A. Of course, Lord, I have given entirely a different color than what the Solicitor General has given. Your Lordship's pleasure is, if you want to read it, your Lordship may read it or omit it. Now, Lord, I come to the 5th point. What is the meaning of the word minority? Mr. Dwivedi has elaborated a lot. I must confess, it is a very novel way he put it. And your Lordship will deal with it, the treatment that it deserves. But actually, to my mind, minority in Article 30 does not mean numerical minority, which is the general trend of this court. It means electoral minority. A minority that cannot affect any elections. Like take up the case of Zoroastrians.
But it will vary from constituency to constituency. There may be some constituencies where you can certainly affect the elections.
But Lord, your Lordship,
So do you look at it at the whole statewide level, the national?
your Lordship will just permit me to just complete this point, then ask. Otherwise, I just want to finish within 5 minutes.
Yes,
I want to finish it.
yes.
We will continue after lunch.
Lord, democracy is a basic structure of the Constitution. Lord Acton, in his Essays on Freedom, says, most certain test by which we judge whether the country is really free is amount of security enjoyed by minorities. That's Lord Acton in his Essays on Freedom. It is mentioned here in paragraph number 2, my lords. This is the reason why rights to minorities were given under the Constitution. Now, if this is the case, then any minority which affects the election results is not a minority under Article 30, but like take up a case of Zoroastrians, that is Parsis and Iranis. Those who came 800 years ago, my lord, Persia was there, they are known as Parsis. Those who came 200 years ago, Iran was formed, they are known as Iranis. Now, they are about less than 1%. Bauds are less than 1%. Sikhs are less than 1%. They can't affect, Christians are 2.4. They can't affect any elections. Muslims in 211 census were 14.2%. But their population is the highest. My Muslim friends, when I talk to them, how much do you form the population? They say, now we have become 23%. So they is Muslims as a minority affect the elections. And that is what, if Bhindawale was a creation of Mrs. Gandhi, then Owaisi is a creation of BJP. They want to divide the Muslim vote. Wherever they combine together, they win. You will have your chance. You will have your chance.
But
that's the way I thought.
Will not steer away from the area of constitutional law.
But what your losses were, you're rejected. Your lordship may reject it. I'm again saying that. But I'm trying to say is,
Let's not comment on
all right,
political personality.
your lordship may not comment it. Your lordship may hear the next sentence which I'm going to say. Because I just mention it as a reference. Your lordship, this court is not competent to decide this question, whether they affect any elections or not. That is why, my lord, I mention that your lordships may have some kind of commission may go into this question. That's all.
So according to you, Muslims are in a position to affect electoral outcomes, and therefore they are not a minority, according to you.
That's right.
That's
And
it.
for that, your lordships cannot go into this. No court can go into this question. A commission may be formed. For that, I was laying down the basis, my lord. I also know, I understand much better than Mr. Sibbal what are the limitations of the court. As a judge also, as a lawyer also. This is all that I have to say on this point. My lord, the Chief Justice has asked a particular question to Mr. Kaul. He gave a particular answer. I have given a different shade to it. If your lordship may have page 4. Paragraph 4. I'll just read it. The 6th and the 7th one, I'll read first the submission, and then I'll read my answer. 6 is the Principal Act, that's the original act, as amended from time to time, was further amended in 1981, the 1981 amendment. By this amendment, the 4 major changes were claimed. The most important change is section 2L. Definition of the university. Then your lordship may come to the 7.7a. Assuming though not admitting that basis of Basha case was changed, thus rendering it the Basha case as no longer a good law, then these amendments are illegal on the following ground. Number 1, they are arbitrary and illegal. B, they go against the secularism and equality basic feature of the Constitution. Point number 6 and 7 are dealt in page number 4.
Thank you so much. Now,
No, I'll just take 2 minutes more. Just let me complete.
Yes, certainly. Tell us, we will hear it for a minute.
Sure. I'd like to read this particular point. Please.
Sure, you can read it. Which point, Mr.
Page 5. Page 4.
Page 4.
Look, I'll take 5 minutes more in case your lordship can give me just 5 minutes more after the. All right.
Seeking 5 minutes, then we'll take on reading it. Yes.
6 and 7.
Yes.
In Basha case, it was held that AMU was established by the Principal Act. Kindly see the second submission on Annexure A. This finding cannot be reversed unless the basis is changed. This can only happen if the status quo ante or the way the things were before the Principal Act came into existence happened. In other words, the Principal Act is repealed and administration as well as properties are reverted back to MAO. Declaration in section 2L, broadly providing the university to mean educational institution of their choice established by Muslim, is not inserted with retrospective effect and is pure fiction. As in Haddock and Haddock, that's a dissenting opinion of Justice Holmes, which later on became the majority opinion. Fiction always is a poor ground for changing substantial rights. It's a dissenting opinion, but some words of wisdom. Then you'll also come to next page. There is no change in the basis for decision in the Basha case. The legislature cannot reverse it. Section 2L providing artificial definition to the word university is arbitrary. An arbitrary statute provision violates Article 14 and 16. I mentioned number of acts, but Lok Prairie case is the best case for all. Then secularism and equality are the basic feature of the Constitution. I have cited Justice P.B. Garkar. Probably this book is not there with your Lordship library. I have the book in case your Lordship wants it, though I have annexed the relevant pages there. Then there is Austin Derwilka quotation. I don't want to. There's a very good book by Justice Cheddappa Reddy, where he talks about secularism was not part of the Constitution, was nowhere mentioned in the original Constitution, but how it was part of the Constitution. That's what he said. And the crux of all this is Indian secularism respects all religions. It does not favor any particular religion. Once you establish the institution for a particular religion, it violates the basic principles of equality, secularism, Article 15. Now, look, this is one particular case was not mentioned precedent. Let me explain this and then I'll finish. It was yesterday my young team suggested to me to put it there. You also must have read Spider-Man comics in your childhood. Spider-Man has a kind of a toy. From here, he can throw this web. Now, this was subject matter of patent dispute. It went up to Supreme Court. The Supreme Court was, US Supreme Court was asked to reverse a decision which they have already taken. What they ended up saving, the advice of Uncle Ben to Peter Parker. With great power comes great responsibility. Will it be your Lordship's pleasure? And they did not overrule it. That case was 51 years old. Here it is 55 years old. Kindly read what the US Supreme Court.
But they overruled Roe versus Wade.
Your Lordship will read it here. I will read, which is in my favor. Dr. Rajiv Dhawan is a very competent lawyer. He probably I personally rate him as somebody who knows the law, there's no other person who knows as much law as Dr. Rajiv Dhawan. I have a great fascination. I grew up doing a hero worship for Rajiv Dhawan. He used to live very across the road. Hero worship for him.
I'm embarrassed.
No, Rajiv, you are undoubtedly one of the greatest advocates India has seen.
Thank you.
Your Lordship, I just.
We'll have a look at it.
Huh?
We'll have a look at it. Thank you.
Can I read that particular line?
No, we've seen that judgment, yes.
And just one more. Look, one more incident I will try to tell your Lordship. That will bear in mind that not 30 seconds I'll take. Look, Andre Weil was the greatest mathematician of last century. He was impressed by Gita. And during World War, when all the scientists were running away, he was a Jew. He came back to India. Schrodinger was supposed to come to India. He got appointment at Allahabad University, and he got, unfortunately, a professorship in Aligarh Muslim University. Now, he was impressed by Gita. India was a land of promise. He wanted it to be, he always used to quote Gita. He used to take them. There's a principle of equivalence. He says, there's a new avatar. Like Vishnu had 10 avatars, that's how he used to do. And unfortunately, he was trapped in AMU. Now, AMU had an atmosphere, which was, let's say, put it, anti kind of a thing. And they tried their level best. You actually hear me. Look, there's some relevance. There's some relevance, otherwise I wouldn't have insisted. He went back. He left AMU, embarrassed. Had he been here, India would have been, AMU would have been Princeton. AMU would have been Stanford. And India would be producing one of the finest mathematicians, and we lost that. I'm obliged. Oh, yeah.
Now, anything else that has not been said, we'll give you
Yes, I have.
30 seconds. Yes.
Sir, 30 seconds I will complete. Sir, volume 2C, page number 2, and I will highlight only 2 points of my written submission. And
What are the points? Just tell us already.
to consider the minority status of the Aligarh Muslim University under Article 30 of the Constitution, we have to examine, can an educational institution created by the Parliamentary Institute enjoy minority status under Article 30 of the...
Mr. Sharma, this has been argued, repeated.
Sir, let me, I am completing the chair, sir. Sir, please 1 minute. If the answer is yes.
50 बार यही हुआ है इसमें बहस इसी point पे आप.
That side, so that's why. Please, one.
You are supporting that side.
Sir, being an intervener, and as a respondent, any respondent can support.
You are supporting the petition. You are supporting the petition.
Yeah, sir.
I don't think they require your support right now. You argue.
Please 1 minute. Sir, I am only requesting you.
Yes.
Sir, then there can be two ways. If an educational institution has been established for minorities under the Act, it should be declared a parameter for granting it minority status under Article 30 of the Constitution. If the spirit of creating educational institution by the Parliamentary Statute is for minority, it can also enjoy minority status under Article 30 of the Constitution.
Okay.
Now,
We'll take that.
the Aligarh Muslim University is the well-established fact is created by the AMU Act 1920 and passed by the imperial legislature. Let me say, when they used the word Muslim in the AMU Act 1920. Secondly, Mr. Surenath Banerjee was allowed to speak in that time in the debate as the representative of the Hindu community, and he praised and supported the bill. And also that time Governor General
But you have to-
congratulated
My lord, I'm,
the Muslim community. Clearly the spirit of the act was in the favor of
Lordship, I'm
Muslims, sir.
representing respondent number 10 and 11, original writ
So that's why.
fought for the reservation, when the reservation was sought to impose
Right.
by the ME. So my lord, just, I don't want to repeat anything, but I want to highlight one very crucial aspect. Kindly see, I discussed how the genesis of the AMU lies in the 1920 Act. If we started from the 1872, there were two groups, moderate, called Wafadar Party and all. So my lord, there were two prominent figures who were the part of the moderate groups. One was the Muhammad Safi, who tabled the bill. Page 43, volume 4C. It is specifically mentioned while tabled the bill, the Muhammad Safi said, the AMU, like the BHU, having the all India character. All India character means, your lordship, the national character. Second prominent figure was Dr. Maulana Azad, our great leader. He was present in the 1920, along with the Muhammad Safi, that group. Another group, of course, did not agree, and they started the Jamia. They passed the resolution Jamia in the Aligarh itself. They started classes there by occupying some of the classroom, and thereafter shifted to the Delhi, your lordship. Now the Maulana Azad, who was right in the 1920, also was in the Constituent Assembly, was the part of the Constituent Assembly.
There has been argument.
And he was also.
You're not here all the time. We have been here all the time.
And he was also in the 1951 at our first education, Mr. My lord, kindly see.
Thank you. We'll come
I love
back
the
now.
legislative your lordship, kindly allow me just 5 minutes, nothing more.
This side now.
This I,
Upon you now.
your lordship,